Political tensions in River State appear to be easing after recent interventions and a court order halting the impeachment process against Governor Siminalayi Fubara. While the state was calm on Monday, with normal activities around government areas in Port Harcourt. This follows a high court injunction restraining the state assembly and the chief judge from proceeding with impeachment, a move initiated earlier this month amidst Fubara's ongoing feud with his predecessor, Nyesom Wike. While sources close to the governor attribute the easing tension to his recent meeting with President Bola Tinubu abroad and sustained mediation by Niger Delta elders. Meanwhile, the All Progressives Congress remains divided internally. The party's national spokesperson disowned a statement from one Rivers faction opposing the impeachment, highlighting the party's internal rift. Well, elders mediating the crisis say sustainable peace depends on President Tinubu's national APC leaders and Nyesom Wike urging all actors to adhere to the rule of law. Well, lawyer and national coordinator for the Advocates for People's Rights and Justice, Victor Giwa, joins us now on Newsday to discuss the River State lawmakers' bid to impeach Governor Fubara and his deputy, and if the court has powers to arrest the impeachment. Welcome to the show. Thank you so much for joining me here on Newsday.
Yeah, thank you so much for having me.
I want to discuss some of the terms of the alleged impeachment. Section 188, subsection 11, defines gross misconduct as whatever the House of Assembly deems it to be. Does this give the lawmakers absolute power, or are there implied limits to this definition?
Yeah, thank you very much. Section 188 sub 11 explains and describes and defines what gross misconduct is. And that section says that gross misconduct is what in the assumption or in the mind of the House of Assembly believes in their opinion to be gross misconduct. And section 188 sub 11 goes further to state that such as breach of the Constitution, any violation of the Constitution, and any other matter that is in the opinion of the House of Assembly can be described as gross misconduct. So to some extent, it expounds what the House of Assembly could describe as gross misconduct. So gross misconduct constitutionally is what any state of assembly would deem as a misconduct in their own opinion.
Wide berth for definition, but could you walk us through the mandatory constitutional mileposts that need to be hit, the 1/3 notice, the 2/3 of a vote, and the chief judge's panel? If any of these are skipped, does the entire process become null and void?
Exactly. When this procedure for removal, as a matter of fact, in the case of the Supreme Court, in the case of Honorable Mustapha Onakoju versus Adeleke, which is the popular Alhaji Ladoja's case, the former governor of Oyo State, the Supreme Court has explained and defined what those procedures should be for the removal. He said the Supreme Court has warned that we should not describe section 188 as an impeachment procedure, but rather a removal of the government, because the word impeachment was defined by the Supreme Court in that case to include an indictment of guilt. And the Supreme Court says that a panel set up by a judge, a seven-man panel could not have established guilt of a governor, so that we should describe that section 188 as a removal of governor. However, the Supreme Court in that same case has also explained that section 188 sub 10 that seemed to be the obstacle clause that limits the court's jurisdiction to entertain or inquire about that process. He said, no, when there is a breach, for example, the notice, like you rightly stated, the notice that is supposed to be sent to the speaker by 1/3 of the members of the House If that notice is sent to the Speaker, the rule, section 118 sub 2(3) says that the Speaker, 7 days after the notice is served on him, the Speaker should serve the copy of the notice to the governor and to each member of the State House of Assembly. Now, it now went further to say that the House shall by a motion decide whether that notice of allegation will be investigated. And the motion to determine whether that notice of investigation will be investigated shall be supported by not less than 2/3 of all the members of the House of Assembly. Now you could see the difference between the first notice and the second motion. The first is 1/3 of the members of the House of Assembly. But when it gets to the motion that will determine whether that notice should be investigated, the Constitution was very clear. The Constitution is not a talkative. They meant every word they use. Now, it said that that particular motion, for that motion to be called a motion, that motion to investigate the allegation, it said that that motion must be supported by not less than 2/3 of all the members of the House of Assembly. Now, so it means that if in the process of kickstarting the removal of a governor, any of that provision is violated, the Supreme Court in the case of Inakojolu versus Adeleke in 2007 says no. We can inquire, we can ask whether that section, whether any provision of that constitution has been violated. In the case of Oyo State, the House of Assembly met in an hotel and they raised the allegation in an hotel in Ibadan. And the Supreme Court said, no, you cannot carry out a legislative duty inside an hotel. And you want to remove a governor. That cannot be done. That will be a total and the greatest absurdity for the State House of Assembly to be meeting in an hotel to serve a governor with a notice through publication. So when there is a violation of each of those sections, the provision of Section 10 can now be entertained to see if the procedures have been violated.
Debate that courts can only intervene after a governor is removed. In the current Rivers case, the High Court has already issued the order restraining the chief judge from forming a panel. Now, is this not a preemptive arrest of the process? Is this something that's legally sustainable?
Good question. I think that is where the mixture is. Yes, in the case of Onakoju versus Adeleke, the case of Dapion versus Darie, the governor was removed. The governor were impeached. But in this case, the procedure has not, ended, has not come into completion. But I need to explain Section 188 sub 10. The misconstruction of that section. Now, Section 118 sub 10 says that no proceedings or determination of the panel or of the House of Assembly or of any matter related to such shall be entertained can be entertained or inquire into by any court. Now, the two principal words there is proceedings and determination. So Section 188 subsection 10 is very clear. In interpretation of statutes, they said expresso unios os exclusion otio. The express mention of one is the exclusion of the other. Now, that Section 10 says no proceeding or determination of the panel or the State House of Assembly. Now, the question you will ask yourself is, what proceeding was inquired into? What determination was inquired into? The word that the court says cannot be entertained is no proceeding or determination of a panel or the House of Assembly. So in this case, what is a proceeding? If the action of the court is to look into the debate whether there was an allegation in the State House of Assembly, that is a proceeding. If the court jurisdiction was invoked to look at what the panel set up by the chief judge are deciding, when they are taking evidence, when they are taking witnesses, if the court decision was to inquire, was to determine what they are doing, it will be a determination. But in this case, what they did was that they stopped the court, they stopped the judge, the chief judge, from setting up that panel. It is not yet a proceeding. It is not yet a determination. So at that juncture, you can go into the court and ask the court to say, no, stop this man from setting up the panel. But when the panel is set up, you cannot stop the process of inquiry by the 7-man panel.
Okay.
If the proceeding of the debate is going on in the State House of Assembly, you cannot go to the court to stop the debate taking place in the House of Assembly because it is a proceeding. You cannot stop it, and no court has jurisdiction to stop the activities in the House.
All right, and just because I have to let you go very soon, concerning due process. Now, if a governor claims that they were never personally served with the impeachment notice, as Governor Fubara and his camp have alleged, does the court still have the power to stop the proceedings on the grounds of a fair hearing?
Correct. The principle of fair hearing is a constitutional matter, and it is in the foundation of our law. So if you cannot pass through the process of removing a governor. In section 188 sub 9, it said the governor, it is the word shall is used. It said the governor shall have the right to represent himself to be represented by himself or a council of his church. So that issue is talking about fair hearing. So if the governor is not served with that notice, he's not in receipt of that notice, then there's no way you cannot just shut up, claim to remove a governor, and where the governor is not even aware of what is going on. It is a strong constitutional process for you to remove a governor. And the governor is saying, I have not even been served with what you are saying, because he has a right to be heard. So it is very fundamental for the court not to inquire what they are doing, but to find out if the governor has been served. So if the governor has been served, then the process can go on. So the governor will not need to wait. And let me state this, it's very important. If you look at section 118, sub 1, the issue of removal of a governor is a may, not a shall. So section 188 does not mean that a proceeding of such must remove a governor. He said a governor may be removed. May, it is not shall. A governor may be removed under this process. So which means the governor at every point can challenge the process, especially what Fubara has done now, to say, look, I have not been served with the allegation. I don't have an idea of the notice you are talking about. And so it is safe for him to approach the court to say, look, I deserve to be served. He's not saying that I cannot be removed. He's saying that, but I have the right to fair hearing so that I should be served and I can face the panel or make my reply to such allegation.
Well, there you have it. Thank you so much for coming in and talking with me today. Justice Victor Giwa, lawyer, the National Coordinator of the Advocate for People's Rights and Justice. Thanks.